Today we're going to continue with Chapter 2, which is Pharmacy Laws, Rules, and Regulations. And we left off last week with the 1990 Omnibus Budget Reconciliation Act, also called OBRA 90. OBRA 90 is my favorite law because this is what forced California to recognize pharmacy technicians. So, like we said last week, it basically says that patients that are on Medicaid or Medicare have to have consultation about their new prescriptions. So since we don't always know who has Medicaid or Medicare, because they may not use that directly, they may bill it through some other subcontractor to Medicaid or Medicare, like Aetna or Pacific Care or one of those insurance companies, we are going to give this type of consultation on all new prescriptions to all patients, no matter who they are, because Medicaid and Medicare, especially Medicaid, sometimes cover people younger than senior citizen age. So if, if the pharmacists have to consult on all new prescriptions, they're not going to have time to do the filling of the prescription. So this is when California started recognizing and licensing technicians. So before that, we were just clerks, and we earned a clerk's wage. And now, now we can actually work as technicians and earn a technician wage. So all patients must be given information on the drug that they're taking, its name, when to take it, how long to take it, and any side effects or possible interactions. And they also usually tell them what the medication is for. So for instance, there is a drug called minocycline or tetracycline and a few other antibiotics that are sometimes given to patients not for like an ear infection or a throat infection. It's sometimes given to them for acne. So a lot of times as technicians, we don't know why they're taking the medication. And many times the pharmacists don't always know either. So they have a tendency to ask the patient, did the doctor tell you what you're taking this for? And then if they say, is it for an infection? And the thing is, when they're taking it for acne, they're actually treating a bacterium called acne vulgaris, which can cause a lot of acne breakouts. So if the antibiotic seems to help, then they know that it's that acne vulgaris that's causing the acne and not something else like an irritating substance that they're putting on their face. So because of that, we don't always assume that patients are taking medication for the usual condition. Maybe they're taking it for something else. And this is especially true with medications that are usually given for sexually transmitted diseases. If we see a drug that we know is used for that, we can't assume that that's what they have. So we never make assumptions about our patients or come to any value judgments about them based on their medications. Okay, so the three important provisions to the OBRA 90 law include evaluation of drug therapy. That's called medication therapy management, or MTM, and technicians can get a little certificate in that if they want to pay for it and take the course. And it's basically preparing all of the medications that the patient is taking and all of the over-the-counter products the patient is taking, as well as any supplements that the patient may be taking, and getting that list ready for the pharmacist to do this medication therapy management. So we sometimes have to question the patients because they might be taking medication that they got from a different pharmacy. So it's not going to come up in our computer if they got it from a different pharmacy. So we have to maintain these patient profiles. So the three important provisions in this law are the evaluation of drug therapy, review of drug therapy, and drug utilization evaluation. And that's important to maintain the patient profiles, because otherwise we wouldn't know that they're taking all of these things. Yes, Bruce, you can come and say hello again. He loves to interrupt me. So a lot of states adopted the OBRA law to apply to all new prescriptions for all insurances, which is what California did. Federal law only deals with Medicare and Medicaid. Then we have the 1990 Anabolic Steroid Control Act, and so this is resulting in harsher penalties for the abuse of anabolic steroids and their misuse by athletes, because some of these drugs increase muscle mass, which, you know, would help athletes, of course, with their particular sport. But also a lot of these drugs are testosterone based or growth hormone based, and the testosterone based ones can cause a great deal of what they call roid rage, steroid rage, because they have a tendency to feel extremely, what's the word I'm looking for, proactive. You know, they're not going to put up with anything, and sometimes they can get into a bad mood and all of that. And they're more likely to, say, have a fight in the parking lot if they're taking steroids. So the 1990 FDA Safe Medical Devices Act, this is also known as the Humanitarian Device Exemption Safe Medical Devices Act. This encourages the discovery and use of devices intended to benefit patients in the treatment and diagnosis of diseases and conditions that affect fewer than 4,000 individuals in the US. Because insulin pumps are becoming very popular, insulin infusion pumps. But in the beginning, they weren't sure how many people were actually going to be able to use it, so they didn't necessarily want to, you know, go to the trouble of designing and manufacturing this. Bruce, you have to get down, darling. There you go. So it requires that all medical devices be tracked and records maintained for durable medical equipment, DME, durable medical equipment. Now, on a side note that doesn't have to do with this act, durable medical equipment are things like the chairs that people can have in their homes that contain a container in the seat to go to the bathroom. They call them potty chairs. Or the devices that go onto the toilet seat to raise it up so people with bad knees can get on and off the toilet safely. Chairs that go in the shower that are safe in the shower, that have the rubber stoppers on the bottom, or the rubber feet on the bottom, so that the chair doesn't slide around in the shower. Medical beds that are raised and lowered as needed. Different things like that. Walkers, patients' walkers. Now, a lot of these things are covered by Medicare, Medicaid, and a lot of insurance companies will cover them too, but they have to be billed separately through DME billing, durable medical equipment billing. Now, I have had students in the past that were hired straight out of pharmacy tech school to do billing on these pieces of equipment for pharmacies that do a lot of sales of over-the-counter DME. But if they're on prescription, then of course they can bill them to the insurance company. So they have to have like an order or a prescription for, say, a walker or something like that, or a cane even. So that's an aside note, but it's kind of important because I think that we tend to think of us as just pill counters, but we do a lot of other things as well. Okay, the Americans with Disabilities Act, the ADA, passed in 1990. It prevents discrimination against potential employees who may possess a disability. Businesses must make a reasonable accommodation for the potential employee. So let's say that you work somewhere for a long time and all of a sudden now you're in a wheelchair. Now the business has to make a reasonable accommodation. Okay, so we actually have case studies on this. I've seen it happen. So they basically have to find something for the patient, or not the patient, for the employee to do in the pharmacy where they can still be in their wheelchair or something like that. So you may actually see employees in wheelchairs working in the pharmacy. The ADA also covers things like housing. And when it comes to accessibility, like for instance, some pharmacies had to revamp their public restrooms with what they call a handicap stall, but now we call it an ADA stall, so that it has room for the wheelchair to get into the restroom stall. And I have a sister-in-law who's been in a wheelchair since 2003. She had a hemorrhagic stroke and she was only 53 when it happened. So that was extremely heart-wrenching for the family, but she's doing very well. but she is one of these Americans with a disability. She's mostly in a wheelchair. She can walk short distances, but not very far, and she doesn't have very good balance. So she's retired at home, but you know, a lot of people still want to continue working. So as far as, you know, from an employer standpoint, they have to make reasonable accommodations. Doesn't mean they have to pay them to do nothing. That's not reasonable, okay? The 1990 Nutrition Labeling and Education Act, the NLEA, gives the FDA authority to require nutrition labeling on most foods. So that means that vitamins, minerals, and other nutrients have to be on the label, and in some cases they have to be highlighted. It requires nutrient content claims such as high fiber, low fat. They have to meet the FDA regulations. If they say that they're high fiber, there is an amount of fiber that must be in the product before they can use that. If it says low fat, it has to actually be below a certain percentage of fat. So for instance, whole milk is only 4% milk fat in the whole container. So it's not as bad for you as some people think. However, when they started taking out half of the fat, and now it's 2% milk, they started calling it low fat when they first started doing that. And then now they have to say reduced fat. They're not allowed to say low fat. They have to say reduced fat because it's half of what the normal fat content for most cow's milk is. So that's one of those FDA regulations that they had to change their wording in order to comply with. But it doesn't require restaurants to comply to those same standards. So you'll see the little, like for instance, a little leaf designation next to an item on a menu. And then you go down to the bottom of the page of the menu and it'll say the little leaf designation means vegetarian. And so there's a difference between vegetarian and vegan also. So all of those things are actual laws that they have to follow regarding what exactly does that mean. Right now there's a big controversy going on and a lot of decisions are going to be made eventually regarding the word organic, because organic does not necessarily mean that no pesticides were used in the growing of this product. You'll see a whole lot of things that are called organic that that don't always mean the same thing. And does organic for fabric that we use to make clothes, like organic cotton, does that mean the same thing as organic on foods that we eat? And so that's another thing that they need to actually come to an agreement on. The 1994 Dietary Supplement Health and Education Act. This was called DSHEA. And it says that herbal products are dietary supplements rather than drugs. Manufacturers are allowed to make claims in regards to good health. And again, that's another thing. What is good health? We don't always have the same agreement on that. But they're not allowed to make disease claims. Guidelines are set to prevent adulteration and must follow good manufacturing practices. Herbal supplements must meet requirements and be labeled as dietary supplement labeling that identifies the ingredients by name. So for instance, something like calcium supplements, and I'm going to grab one of those and show it to you. I'll be right back. Okay, so this is a calcium, 600 milligrams of calcium with vitamin D3. And at the bottom it says calcium and vitamin D3 supplement. And it says with 800 international units of vitamin D3. And then right there it says bone health with 2 asterisks. So the ingredients are calcium carbonate and maltodextrin. Maltodextrin holds it into a tablet form. Contains less than 2% of a whole bunch of other things, including some coloring, because calcium is kind of a grayish color, which is not really, you know, something that looks very appetizing, so they color it kind of a really pretty mauve pink. I used to have a suit that color. It was beautiful. Okay, and so then right here we have the disclaimer that says, this statement has not been evaluated by the Food and Drug Administration, and this product is not intended to diagnose, treat, cure, or prevent any disease. So remember, we talked about federal law that says that a drug must do one of 5 things: diagnose, treat, cure, prevent, or mitigate a disease or a condition. So mitigate means to lessen the severity of. So it should make it not as bad. So for instance, someone could have a migraine and they can take Tylenol. It's intended to make the migraine hurt not so bad, but for a lot of people, it doesn't do as much as other drugs do. But it does tend to mitigate it a little bit. So when we're talking about mitigation, if someone is dying of a painful disease, the pain medication that we give them mitigates, but it doesn't cure. Okay, so if that makes sense. And here's where I would, in the front of the classroom, be looking for everyone to say, yes, we understand what mitigate means now. So that's a good thing, and I miss being in the classroom. Okay, so this is that Dietary Supplement Health and Education Act, which is kind of like, there's a controversy over that as well, because in some countries like Germany, they actually evaluate things like garlic to see if it actually does lower blood pressure, or calcium and vitamin D. Does vitamin D actually assist the bones with pulling the calcium into the bones? And this is what the claim is with vitamin D, is that it helps keep calcium in the bones. And so phosphorus is also something that has something to do with that as well. But a lot of other countries are doing this type of research, and we don't have a lot of incentive in the US to do that type of research because of this, and it was updated in 2005 as well, which we'll talk about in a minute. Okay, 1995 is any willing provider law, which means that any pharmacy can participate in any prescription drug benefit plan, like an insurance plan, as long as they agree to the terms and conditions of that plan. And then we have the correlation to that, the 1995 Freedom of Choice Law, which means that if a patient has an insurance plan, they're allowed to go to any pharmacy for his or her pharmacy benefits, as long as that pharmacy agrees to the terms and conditions of the plan. Okay, so if the pharmacy takes their plan, they can go there. Now, this is a very important law, the Health Insurance Portability and Accountability Act. So it's really important that you guys understand that it's spelled HIPAA. There's only one P, and one of my strongest pet peeves is when I see this written as HIPAA, HIPPA. That is completely incorrect. People tend to look at that and go, oh, it's the Health Insurance Patient Privacy Act, and it's not. Or Health Information Patient Privacy Act. No, it is not. The word information is not in here anywhere, and the word portability is not in the name as well. I'm sorry, privacy. The word privacy is not in the name. But the reason we have it is because of information privacy. So it does mean that, but that's not the name. So you're going to get questions on all of your national exams regarding any kind of health care, whether you're a nurse or a doctor or a dentist or a chiropractor or a pharmacy technician, you're going to get questions on this. And a lot of times they try to trick you by saying the law of 1996 that deals with patient privacy is called, and then they'll throw out HIPPA, or they'll throw out Health Information Privacy Act, and people always click on that and get it wrong. So it's Health Insurance Portability and Accountability Act. So let's look at the name a little bit. Insurance portability, what does that mean? What it means is when I take my insurance card into a pharmacy to get my medication paid for, the insurance company has to know what it's paying for. So the insurance company is going to know which medications I get, and that's allowed by law. They're not going to pay for something that they don't know what it is or that they don't think that you need. However, they're not allowed to tell anyone that, so that's the privacy part. Also, when that information is transmitted from my computer in the pharmacy to the third-party biller, which is called I'll come up with it in just a minute here. It's a company that processes insurance for the insurance company and the pharmacy. So when it transmits that information electronically, you know anything can be hacked. So they have to be able to use the strongest possible security in coding and scrambling that information so that even if it gets hacked, they can't read it. So that's the insurance portability. And then the accountability is who's responsible if this information gets leaked. So we're going to talk a little bit more about that. So there's two parts. The first part deals with the patient's right to continuance of health insurance, even when changing employers or loss of employment. This is called COBRA, which is the continuing of benefits. And I don't remember exactly what COBRA stands for, but I know part of it is continuation of benefits. However, a lot of people don't sign up for COBRA because COBRA is expensive. So they have a right to it. They may not be able to afford it. The second part, the Title II, is the administrative simplification. This established electronic transaction and code set standards and required a health information privacy policy. So every pharmacy that you go to, the first time you go there, they're required to offer you a copy of their privacy policy, which lets you know how they're going to use your information, which is basically to get the insurance company to pay for your medication, and how they're going to try and keep it private so that everybody else doesn't know your information. So now in pharmacies, pharmacists and technicians have direct knowledge of a patient's medical information. So the patient has to sign a consent form to grant others access to this information. So they'll actually come up on a little sign pad on the screen that says, I have received a copy of the HIPAA notification. And it's an actual pamphlet we have to hand out. And so in this pamphlet, it outlines all the things that the pharmacy does to protect patients' health and what they use the information for. And in that pamphlet, they call it PHI. PHI stands for Personal Health Information. I've also seen it stand for Protected Health Information. So it's basically anything about the patient's health, because not everybody needs to know. Patients have a right to privacy. Patient confidentiality prevents privileged information about a customer from being disclosed without his or her consent. Now, this covers past, present, and future health and physical and mental health. It also covers the past, present, or future payments for health services received, the specific care the patient is receiving now or received in the past or is willing to receive in the future. And then any information that can identify the patient as the individual receiving care. So their name, their date of birth, their address, their medical record number, their phone number. So all of that, any information that someone could reasonably use to identify a patient as receiving care. And the reason for this is patients have conditions that are either embarrassing or that could be used against them. Okay, so changes have been made throughout all the medical facilities in the US and medical information centers that limit access to patient information. All of the individually identifying health information is protected, and this pertains to information in any form or media. Now, public health. Every county has a public health department, and every state has one, and then the United States has one that oversees all of those. And so with the public health, we have to know things like, where is COVID? Who is it, where is it spreading in the community? Why is it spreading in the community? And I always said that if I went and got a master's degree, it would be in public health, because what they do is they try to prevent things like COVID-19. So here we go. We finally have an example that sounds a lot better than the 1918 flu epidemic. Now we have a modern pandemic. So in order to do public health activities, their protected health information can be disclosed to public health authorities and the entities that are subject to FDA regulation, to those who may have been exposed to a communicable disease, and to employers regarding work-related illness or injury to comply with OSHA, which is the Safety and Health Administration laws, Occupational Safety and Health Administration. Okay, so also for law enforcement purposes, PHI may be disclosed as required by law, like with a court order, to identify or locate a suspect, fugitive, material witness, or missing person, or to provide information about a victim, or if criminal activity caused a victim's death. So one example of this that I have is a patient in Arizona who knew that he had tuberculosis. He was told, you have tuberculosis, you have to take this medication, and you have to stay home for a certain length of time after you start taking the medication, because you can give this to other people. So he was supposed to go on an 18-month course of therapy. But for the first several, like 3 months or something of it, he had to stay home and not come into contact with other people, because tuberculosis is extremely hard, not hard to treat. We know which medications help, but it takes a long time to completely clear it from a person's system. So he wanted to go fly to England and get married. His girlfriend was there, and she, had planned this huge wedding, and he had to be there. So he got on a commercial plane and flew to England. And the public health department in his county found out about it. They alerted Interpol, and Interpol met the plane on the tarmac in England, and they arrested him and put him on a chartered flight back to Arizona, and he was put in jail because on that airplane he exposed over 250 people to his tuberculosis. And some of them later, they had to be told about it, of course, all of them did, and some of them later actually tested positive for tuberculosis because of this man who refused to believe that he could harm other people by going out in public. So this is one example of that. And then, of course, he got this huge bill, and he was sued by some of those people that ended up with tuberculosis. And he got a huge bill for the charter flight and for the cost of having Interpol arrest him, and then the processing of him into jail. So, this was an extremely bad decision when he should have postponed the wedding, but anyway. And of course, he still did not get married because he didn't actually get off the plane. He got off the plane to go to another charter plane. So how is information protected via the computer? So we have this thing called the National Institute of Standards and Technology that deals with computer encryption. Now, hackers are constantly getting better at reading this information, so the encryption thing has to continuously evolve in order to stop hacking. So it has to be a non-readable format. So what are the patient's rights regarding this? They have to ask to see, they are allowed to ask to see and get a copy of their health records. They are allowed to request corrections to their health information. They have to receive a notice that tells how their health information can be used and shared. And then if they believe their rights are being denied or their health information isn't being protected, they can file a complaint with the provider or the health insurer and file a complaint with the US government. So here's some things that we need to know as pharmacy technicians. We cannot talk about patients with someone that is not actively working on their case, okay? So we can't give out any personal or medical information pertaining to the patient to any entity that's not covered under HIPAA, and we can't share any information with any family member or friend, coworker, manager, or any entity not covered under HIPAA. So if we go out to lunch or out to dinner after work, and we might have a glass of wine with our coworkers, and we might say, oh my God, that Mrs. Smith, doesn't she drive you crazy? Well, she can't help it. You know, she's bipolar. We can't talk about that because people might hear us. And not only that, but if your coworker is not actively working on preparing medication for that patient or getting it billed, then they don't need to know any of that stuff either. So we really have to ask ourselves, what do I need to know to do my job? And in the hospital, there's all kinds of information in the patient's medical record, and certain screens we look at normally, such as what medications they're taking, who prepared those medications, because when we scan a medication into the computer, it will say that we prepared it, and who printed the label, when was the label printed, where was the label printed, so we can see you know, where this information goes. But if I look at information regarding the patient's parents, how to get a hold of them, I don't need to know that information. I'm never going to talk to the patient's mother. I don't need to. So if I go and spend X amount of time on the screen that I don't need to be on, it alerts our IT person, and they're going to talk to me. Why did you look at this information? Because I logged into the computer, so they know where I go on in that software. So this is something that we really need to tell ourselves. Do I need to know this information in order to do my job? And if it's no, then don't look at the information. So things that are not covered, if you work for a health plan or covered healthcare provider, the privacy rule does not apply to your employment records. So in other words, if you called off work for 12 days in a row, that doesn't apply. In other words, the employer can share that you called off 12 days in a row. That falls under other laws, but they can't say, oh yeah, she said she had the flu, okay? So it doesn't protect your medical or health plan records if you are a patient or a member of the health plan. Okay, so that's HIPAA, and that's the nutshell of it. But we also need to realize that we can be jailed and fined up to $250,000 for violating HIPAA. Not only that, but there is something called the Health Provider Data Bank, and a prospective employer can request a review from the data bank. And if you did violate HIPAA and get in trouble for it, it will make a record of it in that data bank. So they will see, oh, look, you got in trouble for violating HIPAA. Does that mean they're going to hire you? Maybe not, you know, maybe it means they won't hire you. So, you know, this is something that comes up on the data bank background check. So, you know, when we do a background check, not only do we look at local law enforcement, they also do the fingerprinting, and they look nationally to see if you're listed on anyone's criminal records. And then it also looks at that data bank to see if you broke any rules from the American Medical Association or the state boards of pharmacy. And then it also sometimes runs a credit check. So the credit check, we tend to think, why would that be important? But there's reasons why they run a credit check as well. So we need to realize how extremely serious the HIPAA law is, and, you know, not talk about our patients, basically. Okay, moving on, the 1997 FDA Modernization Act, the federal drug legend, which says federal law prohibits the dispensing of this medication without a prescription, is now represented by the abbreviation RX on the label. The 2000 Drug Addiction Treatment Act, called the DATA 2000, basically says that physicians can prescribe controlled substances to persons suffering from opioid addiction. It's only for maintenance or detoxification treatments, and the patients must be in a treatment program in order to get it. There's a drug called methadone that they use to wean patients off of opioids. And you won't get you know, a methadone prescription sent home in a 60-day supply. They just don't do that. The 2003 Medicare Modernization Act, this pertains to patients over 65 or patients younger than 65 with a disability or with kidney failure. It provides a drug discount card for those with low incomes who require assistance from a pharmacy company to obtain medications. In other words, if Medicare doesn't cover it, then the drug companies have to assist with paying for it. So sometimes it's a good deal and it gets them a really low price on medication. Sometimes they can't even afford that, so sometimes it works. It adds preventive medication benefits to senior citizens now that covers their flu shot, for instance, lowers the reimbursement rates for Medicare payment for durable medical equipment. And it also created the Medicare Part D prescription plan. Before this, patients on Medicare did not have coverage for prescriptions unless they signed up with, say, Aetna or Senior Care or Pacific Care or some of those plans, and then it would only cover the drugs that they covered. So the Medicare Part D allows them to enroll in either regional-based insurance plans or national-based insurance plans, and it was supposed to expand the medications that they could get on Medicare. 2004, the Isotretinoin Safety and Risk Management Act. This specifically targets a drug that's used to treat acne called Accutane. Now, Accutane is a vitamin A derivative, which is why they named it Accutane. However, it causes severe birth defects, and you can even Google Accutane babies and you'll come up with pictures that are just horrendous to look at. Sometimes this isotretinoin causes spontaneous abortion, which is what we call a miscarriage, and produces adverse psychiatric effects. So when this was put into place, it required mandatory registration of all patients, practitioners, and pharmacists. There's a yearly evaluation. They can only get a 30-day supply. They have to have blood testing during treatment and every 30 days. And they have to have monthly education and testing of patients to avoid pregnancy. So you might think this only applies to women. However, it affected sperm quality in men as well. So women who were not taking Accutane, but their father of their baby could still have a baby with a birth defect. So, and it did other things as well. It raised cholesterol. It caused skin dryness, very, very dry. If a patient got a cut while they were on Accutane, they could get a keloid scar on that cut. So keloid scar is where it's really lumpy and ropey looking. Okay, so it's a raised scarring. Nosebleeds, lip chapping and bleeding. Okay, so it was really strong. So why would anyone take this medication? This medication clears up acne. And if they take it for a few months, it tends to clear up acne in the long term as well. So they might have to take it for 2 or 3 months and then go off of it for several months. And then if the acne comes back, they take it for another few months. So there is no refill on Accutane. And every single capsule in the little blister packs have a picture of an outline of a pregnant woman with a line through it to remind them, don't become pregnant while you're taking this. And they also recommend to wait several months to become pregnant after going off of Accutane as well, because some of it can remain in the bloodstream. The 2004 Anabolic Steroid Control Act. This was an amendment of the 1990 Controlled Substances Act and replaces anabolic steroid definition. These are now Schedule 3, and it eliminated the requirement to prove muscle growth. In other words, we know that anabolic steroids, which are mostly testosterone-based or chemicals similar to testosterone, which we call a type of designer drug, are now all Schedule 3, so they're controlled substances. And it increased the number of anabolic steroid to 59, and I believe there's more now. And it provides requirements for registration, security, labeling, inventory, prescriptions, disposal, importation, exportation, and criminal liability for anabolic steroids. In 2005, we had the Combat Methamphetamine Epidemic Act. There are several drugs that can be made into methamphetamine or meth. The most common one is pseudoephedrine. So this law addresses all areas of the manufacture and sale of pseudoephedrine, an ingredient used to make methamphetamine, as well as law enforcement. This is not a controlled substance. It's available over the counter, but it's actually behind the counter medication, which means you have to ask for it. Only a licensed pharmacist or technician may sell, dispense, or distribute this drug. The maximum amount that you can buy at one time is 9 grams within a 30-day period, and there is a log book. Now, we used to actually have, you know, a log book that we had to keep for years. Now it's online, so we're allowed to do it on the computer. It has to have the product name, the quantity sold, the name and address of the purchaser, and the date and times of sales. The 2008 Prescription Drug Equity Law. Oh, and one of the things that the 2005 Combat Methamphetamine Epidemic Act does, and especially now that these logbooks are online, is it sends this information, and so we can see if someone has purchased more than 9 grams in another pharmacy, it will come up that they can't purchase it with us. Okay, the 2008 Prescription Drug Equity Law. This prohibits a prescription drug plan from requiring mail order prescription drug coverage without also providing a non-mail order coverage. So in other words, there are a lot of mail order pharmacies. There's more in California than there used to be. They used to all of them be up in the areas like Minnesota or Illinois, because wages are lower there, and sometimes the cost of running a business is lower there. So they would open these huge mail order pharmacies, and you would have to wait to get your medications from Wisconsin or Minnesota. But now they're saying they can't require that. You can also, if you want to, you can get it at your local pharmacy. However, they are allowed to give you a big discount from going through the mail order plan. And they're also allowed to give you, say, a 90-day supply for the same price that you can get a 30-day supply here in your local pharmacy. So they are allowed to make mail order more attractive to the patient. They're not allowed to require it. 2008 Medicaid Tamper-Resistant Prescription Act. This applies to all handwritten prescriptions for covered outpatient drugs. Drugs that are transmitted from a prescriber, verbally, fax, or e-prescribing are not affected by this act. It only applies whenever Medicaid pays any portion of it. The pharmacy may accept a faxed prescription until the physician's office has a tamper-resistant prescription pad. The tamper-resistant pad, the prescription paper that they write it on must have one or more industry-recognized features to prevent unauthorized copying, erasure, modification of information written, or use of prescription counterfeit forms. The pharmacy may fill the prescription for the emergency purpose, but must receive proper documentation from the prescriber within 72 hours. Okay, so it looks like the Controlled Substance Prescription Act, okay? But this applies to all Medicaid handwritten prescriptions. So the pharmacy the prescription may be transferred to another pharmacy by fax or phone without the pharmacy verifying the original prescription. 2010 Patient Protection and Affordable Care Act, the ACA, makes preventive care more accessible and affordable for many Americans, requires insurance companies to cover all applicants with new minimum standards, including pre-existing conditions. And there's two important things that technicians need to know about this. There are electronic health records that have to be maintained and have to be kept private. And also the medication therapy management and Medicare Part D also apply to technicians. And we talked about those a little bit earlier. So there is a website, hhs.gov/OPA/affordable-care-act/index.html. And that gives you a lot more information on that. I'm not going to make you go to that website. I already made you go to a few websites. Okay, so the 2013 Drug Quality and Security Act. This gives the FDA a tracking system for bulk compounding supplies through the distribution process. That's because in 2012, there was a compounding pharmacy in Massachusetts who was making, they were making injectable drugs, and they had a fungal contaminant in their laminar flow hoods or somehow in the process of making these meds. And it caused fungal meningitis. And so we had these outbreaks of meningitis, and they were all over the country. They weren't just in Massachusetts, but they were finally traced back to this compounding pharmacy in Massachusetts. And they got in a lot of trouble for this, as they should have. So there were two separate parts to this Drug Quality and Security Act. The first one is the Compounding Quality Act, which says that there is a new class of compounders that are required to register as manufacturers with the FDA, and that allows them to sell in bulk. So for instance, our pharmacy might compound a prescription, in fact we do all the time, compound an injectable medication, but it's only for a specific patient. We're only going to compound a certain amount at a time, and if we use it for different patients, they're going to be a small amount. So this Compounding Quality Act deals specifically with pharmacies who manufacture in bulk. So they might make, you know, hundreds of these vials of medication that are not necessarily, like, they don't necessarily know who's going to use it or when. So the Drug Supply Chain Security Act also is related to counterfeit, falsified, and substandard prescription medication. It requires the FDA to create and implement a national tracking system that's used by manufacturers and introduce barcoding technology to pharmaceutical products. So they have to have the little barcode on there, and we scan the barcode when we prepare medication so that they know exactly which product was used. So that started in 2013. Now barcoding is everywhere. So an example of this was there was a counterfeit Avastatin out in the you know, pharmacies out there, and nobody knew it was counterfeit until it started not working, and it started, you know, being detrimental to patients to use it, and then they figured out it was counterfeit. Okay, so let's talk about the FDA. So we looked at the laws, and now let's look at who's dealing with all of these laws. FDA stands for Food and Drug Administration. This is the enforcement agency of the U.S. Department of Health and Human Services, and their main function is to enforce guidelines for manufacturers to ensure safety and effectiveness of medication. So any food, drug, or product that contains any avoidable, poisonous, or harmful substance is considered unsafe and adulterated. So here they're talking about things like contamination or dirt that gets into the product, or even things like we talked about arsenic and lead being in face creams that are used to lighten skin. And as someone who tried to tan all through the 70s, I don't understand that, but everybody has their own little, you know, things that they consider beautiful. Beauty truly is in the eye of the beholder. So then the Food, Drug, and Cosmetic Act established standards that prohibit misbranding, adulteration, and misleading labeling of any products before they're provided to consumers. How many packaging standards are there under the Food, Drug, and Cosmetic Act? And this is on, and I'm not sure that it's on page 31 because I haven't updated the page numbers. I always forget about the page numbers when I update these things. No, page 31 is the MedWatch consumer form. So I'm not sure where this is, but it's probably going to be higher than page 31. Okay, so mandatory drug labeling, standards of identity, imitation foods, nutritional information for special dietary products, and then a manufacturer may not advertise false or misleading statements about a product. These are some of the packaging standards that are under the Food, Drug, and Cosmetic Act. Then we have the DEA, the Drug Enforcement Administration. This is created under the Department of Justice, okay? So it's a law enforcement agency. Their main function is to prevent illegal distribution and misuse of controlled substances. This even includes chemicals that people come up with that act like controlled substances that may not even be something that we can think of that exists. So those are called designer drugs. And if they can cause harm, then they fall under the DEA rules also. The DEA issues licenses to practitioners, which is, doctors basically, pharmacies, and manufacturers of controlled substances, and their primary role is to enforce the nation's drug laws. The FDA has a reporting process. So patients can report any defect in over-the-counter medications or any other drug problems, so prescription drugs as well. And they can report any adverse effects or any medication reaction that might cause disability, hospitalization, or death. The patient's identity is kept confidential, as well as the person reporting it is kept confidential. So they can do this with that toll-free number. They can also fill out a form online. So there's this thing called MedWatch. It's the FDA program that allows consumers and healthcare professionals to report any discrepancies or adverse reactions to medications. Even fainting or other types of reactions not listed in the drug monograph should be reported as well. The MedWatch form can be found on FDA.gov, MedWatch, et cetera. And you can, if you go to the www.fda.gov, there's a link right on the home page that takes you to the MedWatch form. So here's a picture of the MedWatch form. Now not patients, but any consumer can print it out and mail it in as well. But most of the time they're going to fill it out online. It's like a PDF that you can actually type on. And there's 3 pages, and this starts on page 31 in your textbook, so you can see that. Okay, so what if a drug is out on the market and it's found out to have some problems with it? They can issue a recall. Now, there's a process to the recalls. Now, the FDA does not typically order the recalls, but they can request in writing a recall by the manufacturer, and then if the manufacturer refuses, then the FDA will order the recall. I'm going to pause here for just a minute. And I'm back. Manny decided to say hello. He's a Sheltie mix from a rescue. Come on, good boy. Okay, get down, good boy. He really doesn't like being on the lap. Okay, so in the recall process, manufacturers can voluntarily recall items that are defective or tainted. They have to notify the pharmacy and give instructions on how to handle the recall. The pharmacy does not have to notify the patient unless it's a Class 1 recall, which is to the consumer level. If mandated, the recall manufacturer must notify the pharmacy and give instructions, and the pharmacy must notify the patient and request item returned. So that's if it's mandated. So there's a voluntary recall and there's a mandated recall. So what happens when we get a recall is we look at what is the drug, what's the NDC number, what's the lot number. So we have to pull the stock and return it to the manufacturer if it's that same NDC number and lot number, because they have to identify which products are contained in this. So here's a recall notice. There's a DCA, which is Department of Consumer Affairs, right here in the website listing, or the address, I mean. DCAlist.ca.gov, and then it says who the company is, which is Baxter in this case, and what they're recalling. Reports of a damaged product that may alter the predicted release of scopolamine following transdermal application. This was a patch for nausea or motion sickness. So we look at the NDC number. The UPC is the barcode on the product that gets scanned at the check stand, and then the lot number and the expiration date. Now, each lot number, there could be several lot numbers with the same expiration date, but a lot number isn't going to have more than one expiration date. In other words, the lot is like the batch that they made on a certain day, and they might make more than one batch on a certain day. Okay, so it'll have the expiration date. So we look at those, and then we see, and usually we'll contact who we got it from, because we use wholesalers. So if we got it from, say, Cardinal, then we'll call Cardinal, we'll call our representative at Cardinal, and they'll tell us what to do with the product. Okay, so there's 3 classes of recalls. Class 1 is for products that could cause serious harm or prove fatal. Class 2 is products that are found to cause a temporary health problem or pose a slight threat of serious harm. And then Class 3 recalls are the products that may have a minor defect or other condition that would not harm the patient. They're unlikely to cause a health problem, but they might violate FDA labeling or manufacturing recommendation or regulations. Okay, so Class 3 recall is the lowest class of recall, and it doesn't cause harm or death, okay? Okay, now we're looking at controlled substances. Controlled substances are commonly known as narcotics, and they are addictive. Narcotics technically are derived from opium or opium-like substances. That is the actual definition of narcotics. However, we tend to call all things, even things that are not a narcotic, we call them all narcotics or narcs. Opium comes from the poppy seed plant and has analgesic effects. Analgesic means it relieves pain and also affects mood and behavior. Opiates are the one derived directly from opium poppies, for example, morphine and codeine. Opioids are also narcotic analgesics, and they're at least part synthetic opiates. For example, OxyContin and Dilaudid are synthetic, so they were created in a lab, and so we call them opioids, which means opiate-like. So each type of narcotic is assigned a rating that depends on its addictive and abuse potential. The FDA and DEA work together when a new drug is proposed, and then they recommend what rating that drug is going to get. However, the U.S. Attorney General ultimately determines which schedule to place drugs in. They have to be labeled. The federal law requires that packages of controlled substances be labeled with a specific symbol and Roman numeral of scheduled class in a large and prominent manner to indicate that the product is a controlled substance. This doesn't apply to patient prescription containers. Okay, and there's 5 levels based on their potential for abuse, and I put this in your file in Canvas. C1 is the strongest potential for abuse. There's no medicinal use in the United States, for example, LSD and heroin. Schedule 2, C2, C3, C4, and C5 are all medicinal narcotic drugs, so they have a legal use in the United States. C5 is sometimes over-the-counter in some states because it has a very low abuse potential. However, not California. California does not have over-the-counter this type of scheduled controlled substances. The only one that's considered that is pseudoephedrine, which is not considered a narcotic until you make it into methamphetamine. The U.S. Attorney General assigns the schedule for a drug. So medication abbreviations that we talked about a few weeks ago, APAP is acetyl P-aminophenol, acetyl P-aminophenol, which is acetaminophen. And then ASA is acetyl salicylic acid, which is aspirin. Acetaminophen also has a brand name of Tylenol, and one of the other generic names in another country is called paracetamol, and I think that's in the UK. Okay, Schedule II drugs must be kept separate from all other drugs in a locked storage area, such as a locked cabinet or a locked fridge or a locked vault. Schedule III through IV can be kept locked in a separate area or dispersed, not locked up, dispersed among the other legend drugs. The main thing is, if they're going to be kept together, they have to be locked up, because you don't want someone to walk into the pharmacy and just walk up to a shelf and take all the narcotics and throw them in a bag and leave, right? So you want to make it difficult for them to find them all. And that's not so much because then the pharmacy will lose less money. It's basically to keep them off the street. Okay. In order to write a prescription for a controlled substance, a doctor has to use tamper-proof prescription pads. And so these new prescription pads have up to 8 different tamper-proof security marks on them that prevent forgery and fraud. They're called security prescription forms. And let me see where they are. Okay, so this is on page 37, and it says figure 2.6. Okay, so it's slightly different, figure 2.6, and it shows the different things. For instance, they have to have a consecutive number like a checkbook. They have to have, for instance, if you make a photocopy of these prescriptions, in the background it will say void, so that everybody knows that it's a photocopy. It'll have micro printing on the signature line that says something like controlled substance, controlled substance. It has a thermochromic ink where you can rub your thumb or blow on it and it will change color. And it's usually either the RX symbol or it'll show a mortar and pestle logo. So here are some examples of that. So right in here is the thermochromic ink part of it. It has a void pantograph with chemical protection, which again talks about that photocopying thing. And then the warning bands. The face of this document has a colored background on white paper. And then there's also a little box on the right-hand side of the prescription that shows initial quantity. So if a doctor is writing number 100, they also have to check the box that says 75 to 100 so that somebody can't write over it and make it a different number. There is a registration required for maintaining narcotics. So DEA has several different forms, and these are the most common ones, the most common forms. Form 224 is needed by a pharmacy to dispense controlled substances. 224A is the one that gets renewed by the pharmacy, and that's every 3 years it renews Form 224. Form 225 is to manufacture or distribute controlled substances. Form C363 is to run a narcotic treatment program or compound narcotics. Form 41 is to return products to a reverse distributor. Retail pharmacies can only request this form from the DEA once a year. Hospital pharmacies can request blanket destruction, which allows them to destroy controlled substances multiple times throughout the year. Some hospitals that are really big and busy might have a reverse distributor come in once a month and collect all of these, and they have to fill this out for every drug that by the NDC number and how many units of this thing. So say 5 vials of lorazepam with this NDC number, or 17 tablets of Tylenol with codeine with this NDC number. And then that has to all be listed on Form 41. for outdated or unused controlled substances that get destroyed. And the disposal must be witnessed by a pharmacist and a law enforcement officer. So we have these companies called reverse distributors. The first one I ever heard about was about 20 years ago, and we used to mail in a big box all of our drugs to Texas. And now we have these reverse distributors all over the place because they can make money by destroying these controlled substances, but they also have to have a license by, from the DEA to be a reverse distributor. And they also have to have usually a business license that pertains to that. And they have to arrange to have a pharmacist and a law enforcement officer witness this disposal or destruction. Usually they burn them. Form 222, this is how we order Schedule II controlled substances, and the file has to be, the copy has to be kept on file for 2 years for DEA inspection. Form 510 is for retail pharmacies that want to engage in wholesale distribution of bulk quantities of drugs containing pseudoephedrine, ephedrine, or phenylpropanolamine. Phenylpropanolamine we won't see for human use anymore. It's still legal for horses. Phenylpropanolamine was a very nice decongestant that I used to take for sinuses, and they pulled it off the market because it was available over the counter in a high dose as a diet pill. I don't remember what it was called. But so women, we started seeing this probably in the late 1990s, where women were showing up in the emergency department having a heart attack, and they couldn't figure out why. Well, they were taking phenylpropanolamine in order to lose weight. Oh, I'm getting married in 5 weeks and I have to lose 30 pounds. Well, you're not going to lose 30 pounds in 5 weeks unless you starve yourself. And it's very dangerous to try and lose large amounts of weight in a short period of time. So rather than say, well, let's not make this over the counter, let's make it prescription only. And I'm telling you, the prescription one only had 25 milligrams, but that over the counter diet pill had 75 milligrams. So I think it's kind of stupid that they pulled the entire drug off the market for use in humans, but allowed horses to use it, instead of just saying, let's keep it prescription only. So, that didn't make any sense to me. And I felt that the FDA had a bad judgment call on that one because it was safe when used as directed. So anyway, if drug companies or pharmacies, retail pharmacies, want to engage in wholesale distribution of bulk qualities, they have to have Form 510, and I don't know any pharmacies that do that. Form 106 is for loss or theft of a controlled substance. So if somebody steals medication from your pharmacy, you have to fill out Form 106 and let the DEA know exactly what's missing. So here's an example of Form 222. So the pharmacy has to fill out who they are, and then they're going to fill in what they want to order, how many packages, what size of package, the name of the item, the NDC number, and then the supplier DEA registration number is going to be filled out there, and then they say how many they shipped. Okay, so this form has to be filled out, and now, of course, we do it online. So it's called an E222, of course, electronic 222 form. Refilling controlled substances, there's strict guidelines on this. Physicians can write up to 3 separate prescriptions at one time for multiple drugs to be filled sequentially over 90 days. The date of each subsequent prescription must be written on the order, and each prescription cannot be filled before that date. Drugs rated C3 through C, okay, so that's for C2 medications. Now, they can also write these 3 separate prescriptions for other drugs that are not C2s, but mostly they use it for C2s. Because what will happen is, say you have a person on drugs, medications for ADHD, like Methadate or Adderall or Ritalin, and they don't need to see the patient for 3 months at least. So they'll write a prescription for this month, a prescription for next month, and a prescription for the following month, so that they don't have to come back and pick up a prescription, because they have to be written on actual prescription pads. Now, if a drug is C3 through C4, so C3 and C4, the doctor can write for a maximum of 5 refills within 6 months of the original order, whichever comes first, okay? So the way that this thing is worded, it looks like you automatically get 5 refills, but you don't. It's up to the doctor to decide. But if they write 6 refills, you're not going to get 6 refills because it's a maximum of 5 within 6 months. C5 drugs don't have a limit on if the doctor wants to write, 7 or 8 refills, but they still have to be filled within 6 months or you don't get the refills. The record must be kept with the pharmacist's initials, the amount of drug dispensed, and the date the drug was dispensed for 2 years. Transferring controlled substances, C2 prescriptions are not transferable. C3 through C5 are permitted to be transferred from one pharmacy to another for refilling one time. The prescription must be transferred between 2 pharmacists. And California law says any prescription has to be transferred between 2 pharmacists. So technicians can't, we can get all the information and we can fill out paperwork and we can call the pharmacy to transfer the prescription, but the actual transfer has to be made between 2 pharmacists. For the transferring pharmacy on these controlled substances, void must be written on the face of the transferred prescription and the transfer date, the name of the pharmacist, the name and address and DEA number of the receiving pharmacy, and the pharmacist receiving the prescription must also be written on the back of the prescription. The receiving pharmacy has to write all of the same information on it and the prescription number that the transferring pharmacy originally gave that medication. Okay, for ordering controlled substances, we're going back to the DEA 222 number. The pharmacy, in order to get it from a distributor, we have to fill that out. If it's in paper, it has to be filled out by the receiving pharmacy in pen, typewriter, or indelible pencil. Now, you'll see a lot of these laws that state indelible pencil, which basically means a pencil that can't be erased. That's because there's legal definitions for pens, and they have to have ink, etc. So I'm not exactly sure what that means. I don't know anyone who's ever used an indelible pencil, but I think it's one of those funny things that you see in laws that don't seem to make any sense. Okay, so if you're ordering on paper, it's going to be a triplicate form with 3 sheets. The top and middle copy with carbon paper are sent to the supplier or the manufacturer, and they have to keep it on file to show who they sold it to. The middle copy is forwarded to the DEA to prove that the medication has been received, and the ordering records for C2s must be kept separately from C3 through C5 records. The pharmacy retains the bottom copy, and the federal law requires pharmacy to keep all controlled substance records for 2 years. State law record-keeping laws are variable, with a number of states requiring pharmacies to keep records for more than 2 years. Okay, so on your national exams, though, they're not going to ask you about state laws, they're going to ask you about national laws. So like the PTCB exam, we'll have a question stating, federal law requires pharmacies to keep records of controlled substances for blank years. So the answer there is 2 years. If the drug is a C3, C4, or C5, they're ordered on normal invoice forms, but they have to be filed and retained for the DEA or the Board of Pharmacy inspection. They should be kept separate from other non-scheduled drugs, and the forms are kept for 2 years, etc. Okay, so now we have all these records, and what we're talking about here is prescriptions for controlled substances. If it's a paper record, it has to be stamped with a red letter C. Okay, so it gets stamped in the bottom right-hand corner with a red letter C. So the first method is to put the C is to have 3 files. Okay, one for C2s, one for all other controlled substances, and one for all non-controlled substance medications. The second method is to separate the C2s and put all the other controlled substances with the non-controls. And then the third method is to put all the controls in one place and all the non-controls in another place. So the question is, what if they write a prescription for a controlled substance and a non-controlled substance on the same paper? How do you know where it is? So what we do a lot of times is we'll take a blank piece of paper that is square like a prescription form. So it's going to be about the size of a prescription. And we'll write on it prescription number, the prescription number, C, S-E-E, so it'll say RX number 106758. I can't read backwards. C, RX 106757, with a little C with a circle, which means controlled substance. So for prescription purposes, that means controlled substance. So we'll have that in the file with the non-controls, because the non-controls have to go in the controlled substance file because it has a controlled substance written on the same page. Okay, so now we have to count the controlled substances and keep perpetual inventory, which means we have to know exactly how much we have on hand at all times. Now, a lot of things will do this automatically, like hospitals will oftentimes have a narcotic room with a drug vault. So we tell the computer there are 17 tablets of, say, oxycodone 5 milligrams. So now we're logging into the computer, we'll tell it we're going to take 1 tablet of oxycodone 5 milligrams, and that drawer will open up and you can take out 1 tablet, but you have to now tell it how many are left, so that you have a continuous inventory, perpetual inventory all the time, so that we know exactly how many tablets of oxycodone 5 milligrams and what happened to the ones that were there before. Okay, so if you don't have a narcotic vault, and a lot of small pharmacies do not, then they're going to have a narcotic inventory book or a perpetual inventory book, and it'll have a page for all the oxycodone 5 milligrams. And when we get some in, we put plus 100 tablets. When we take them out, we put minus, say, 30 tablets for RX number, whatever it was, okay? So that's another way of keeping that perpetual inventory. Here is a C stamp that's used to stamp the prescriptions. What is drug diversion? Okay, so the word diversion is kind of create a diversion and I'll run off with it. That's not what that means. Drug diversion basically says that there is a path from the opium poppy being grown to then being sent to a manufacturer who creates this drug out of it and manufactures the drug, and then it goes to a wholesaler, and then it goes to a pharmacy. Doctors write a prescription, the patient picks it up, and it goes to the patient's home. So it's a pathway, right? It's a journey that the drug takes. If the drug is stolen at any point in that journey, they say it is diverted, okay? So, and of course that's illegal. So drug diversion is illegal, and drug diversion is something that we fight against, you know, continuously. That's the DEA's main task, is to enforce laws relating to drug diversion. So there is a perpetual inventory, one of the things we use, and then it says pharmacists must validate all counts done by a technician. I don't believe that's a federal law, because there have been many times when I've counted controlled substances and I didn't have a pharmacist validate that. But sometimes we have 2 technicians count, or sometimes we will count and then count again if it's a controlled substance. All discrepancies are investigated by the DEA. They're not actually going to investigate if 1 tablet is missing. They are going to investigate if bottles of tablets are missing continuously over several months. Now, federal law, the DEA, requires an inventory of all controlled substances every 2 years. That's what the word biennial means, B-I-E-N-N-I-A-L. B-I-A-N-N-I-A-L. There's another word called biannual, B-I-A-N-N-U-A-L, which means twice a year. So you want to be careful with biennial and biannual. They don't mean the same thing. So the DEA requires an inventory every 2 years, which is biennially. It's an exact count of all the C2 medications, and it says that they require an estimated count of C3 through C5 medications. Most pharmacies that I know of also do an exact count of C3 through C5. So these are overall periodic counts that are done weekly or monthly by pharmacists. Depending on how large the company is, the pharmacy might oversee it monthly, or they might oversee it even just once a year. It depends. Most pharmacies are going to do controlled substance inventory more often than every 2 years. Okay, but the one they report to the DEA is the one that's done every 2 years. Okay, we already talked about a reverse distributor. They don't just take back controlled substances, they take back any drug that we don't want to end up in the landfill, okay, because drug disposal is a big issue right now. Most of the time, if you look at tap water, it might contain some drugs like birth control pills or Prozac, or something that has a really small molecule that's really hard to filter out, end up in our water supply. And even water that's been filtered, like spring water, that's been filtered and purified, sometimes those can also contain just trace amounts of drugs. And they don't normally affect us at all because they're such tiny, tiny amounts. But the more we dump into the landfill, the more these things are going to show up in the water supply. So they started doing a safe disposal of medications law. And this is even over-the-counter things, and things like, vitamins, even. Things that you wouldn't necessarily think of as bad, for you, or eye drops, artificial tears even. So they pick up things like that as well. Okay, so we're talking about filling, refilling, and transferring prescriptions for controlled drugs, which we already talked about a little bit. So this is like a little distillation of that. There's one thing called an emergency C2 original fill. So let's say that a patient is dying of cancer, they're in severe pain, they need the medication right now, and they don't have an actual prescription. So the doctor can call the pharmacy and say, I need an emergency situation for, say, 5 days worth of severe pain medication. And then the prescriber has to either mail the prescription or take it to the pharmacy within 7 days with authorization for emergency dispensing written on the face of the prescription. And there's actually the number of the law. So a lot of times it'll put C, whatever it is, 1117.2 or something like that. I don't remember exactly what it is, on the front of the prescription, which means authorization for emergency dispensing, okay? So we talked about refills, no refills on C2s, 5 times within 6 months for C3 and C4, and C5. And C5 has no restrictions, but they're all only good for 6 months. If you fill a partial medication, you have to have for C3, 4, and 5, and let's say you loan them 5 tablets because you don't have it all in stock. You have to have the rest of it within 6 months. If it's a C2, they have to have the rest of it dispensed within 72 hours. And if the remainder is not dispensed, a new prescription will be needed. So it's not good to get a partial fill on C2s. Some states require Schedule 5 drugs to be dispensed by a pharmacist, and we don't do that in California. All drugs are considered dispensed by a pharmacist in California. Mailing controlled substances, C2 through C5, may be mailed as long as the contents are not identified on the packaging. So you can't put, hey, these are oxycodone tablets in here, you know. The inner container must be labeled to indicate the name and address of the dispensing pharmacy. So you have to say who it comes from. You don't necessarily have to put that on the outer part of it. Most companies will put the pharmacy name on the outside in case it needs to be returned, but they're not going to put, you know, controlled substance drugs on the outside. They're not even going to put drugs. Now, we have some wholesalers in Southern California. We have quite a few. I think there's 3 just in the Inland Empire alone. However, their trucks do not say anything about drugs. It'll say something like the name of the distributor or the name of the wholesaler. So let's say that the wholesaler is named Blue House. It will say Blue House Logistics. Logistics just means getting the product that you want where it needs to go at the time it needs to be there in a usable condition. So that's like the definition of logistics there. It's not the official one, but that's my definition of it. So when it says Blue House Logistics, they could be transporting tennis shoes, you know, we don't know. But I always find it interesting when I see them on the freeway. So I'm like, oh, there's drugs in there. A pharmacy can lend controlled scheduled drugs to another pharmacy, but they have to meet specific guidelines. The receiving pharmacy must be registered with the DEA to dispense controlled substances. The lending pharmacy must record that it lent the medication, and the receiving pharmacy must record that it received the medication. If a C2 is lent, it must be documented on a DEA 222 form by the lending pharmacy and must have the drug information, quantity, name and address, and DEA number of the receiving pharmacy, and no more than 5% of the total number of dosage units of controlled substances can be dispensed by a pharmacy within a calendar year unless the pharmacy is registered as a distributor. So they can't loan stuff left and right unless they are, like, then they become a distributor. We have state monitoring programs. They require pharmacists to submit their controlled substance prescription to the designated state authority electronically on a periodic basis, once or twice a month or more frequently. The programs are used to identify potential diversion and abuse of drugs, whether by the patient, the prescriber, or the pharmacy, and to identify potential patients that would benefit from drug abuse treatment programs. The information includes the patient information, the prescriber information, the pharmacy information, and prescription information, the name, the quantity of controlled substance, and the date the prescription was dispensed. Now in California, it's called the Controlled Substance Utilization Review and Evaluation System, which means, so we abbreviate that as CURES. So they call it the CURES program. Okay, then we have drug monographs and package inserts. Again, this is an FDA regulation that says the particular information needs to be in this giant paperwork because it doesn't fit on the label. It can also be contained in the physician's desk reference in the doctor's office and facts and comparisons in the pharmacy. It's also available through online resources such as the National Library of Medicine's Daily Med website. It includes the description, the clinical pharmacology, indications and usage, contraindications, warnings, precautions, the potential for drug abuse and dependence, the adverse reactions or side effects, the dosage, how much they would take, and how it's supplied, like the form, is it a tablet or an ointment? And then it could also have a boxed warning, which is also called a black box warning. And there's an example in your textbook. The boxed warning warns of problems that we've seen with specific drugs over time. So an example of a monograph is shown on page 44 and 45 of the textbook. The first part, the indications and usage, are what it's used to treat, and it also shows the off-label uses. The drug might not have been approved to treat a specific thing, but practitioners use it for that. The pharmacological class of the drug, to remind doctors of the mechanism of action, and all the limitations, like who should not use the drug. That's the contraindications. Dosage and administration, which is the recommended dose regimen and the dosage range, the manner in which the medication should be administered. There are some drugs that should not be given intravenously, or some drugs that should not be given by mouth, for instance. And the pharmacological information is on there. The third part is the dosage forms and strengths, how supplied. The fourth part is the contraindications, clear situations in which the drug should not be used, and specific conditions in which the risk of taking the medication clearly outweighs any possible therapeutic benefit, the known hazards. And the order that it's listed is based on the likelihood of occurrence and the size of the population studied. So it'll say we had 400 patients try out this drug in the clinical trial, and 16 of them had a bad headache, that kind of thing. So how severe is that risk? Fifth part is warnings and precautions, the most clinically adverse reactions, and also reactions to taken when such reactions occur, and then monitoring parameters. Number 6 is the adverse reactions, side effects, and how to report reactions to MedWatch. Number 7 is drug interactions, which also include foods. Instructions on how to lessen the interactions and any dosage adjustments. Use in specific populations like pregnant women, elderly patients, children, patients with kidney disease or liver problems. Number 9 is drug abuse and dependency. Now, if a drug is not considered something that causes drug abuse or dependency, then there won't even be like a section 9 on here. Number 10, what happens with an overdose? What kind of antidote do they use? Number 11 is a description of the chemical ingredients, chemical agents and ingredients, and the drug formula. That's going to be on the description. Sometimes I see the description up at the top of the page though. Number 12, clinical pharmacology. How does this drug interact with other medications, and are there specific interactions based on the pharmacology? Non-clinical toxicology is number 13, which basically means can it cause cancer? Does it cause birth defects? That type of thing. 14 is clinical studies. Summarizes the most important studies that established the effectiveness and safety of the drug in humans, but not all the studies are included. And number 15 is references, list of reference materials. Sometimes there's not references. Number 16, how supplied and storage and handling. This is the one that we most often look at as technicians, like does it have to go in the refrigerator? How do we reconstitute it if it's a dry liquid or a dry form of a powdered drug that we have to add liquid to reconstitute? Should it be protected from light? Should we treat it as a hazardous medications, which means that we might have to use gloves or prepare it in a hazard hood or a chemo hood? 17, patient counseling information that the pharmacist needs to talk to the patient about. Okay, now the boxed warnings are interesting. They're at the bottom of page 45. They're encased in a black border in the manufacturer's insert. They're called, we call them a black box warning. They're required on medications and products that carry a high risk potential to the consumer. It needs to list how they can use it properly to avoid or decrease those side effects. For example, a lot of antidepressants have a box warning that says that taking this drug, we've noticed an increase in suicidal behavior, which is really scary, right? You're depressed, but you're not suicidal. Well, let me give you an antidepressant to feel better, and then suddenly they're talking about suicide, or they're even attempting to commit suicide, or unfortunately even succeeding sometimes. So most people that take antidepressants do not have this side effect, but it was noticed in enough people that now it's in a box warning. Okay, now med guides are also, these are ones that are handed out to the patient, okay? So they're not going to have, you know, the chemical structure of the drug because patients aren't going to know what that means, okay? So they're going to have the med guide separately for patients. Most of the pharmacies are going to have these in a database, and so when you fill a prescription for a specific drug, it will print out on paper. And so these are going to be dispensed by the pharmacy with every fill, the first time they get it and every time they get a refill. So that's why when you pick up your prescription, you always have a bunch of papers in there with you. Medications that have boxed warnings, they are required to have med guides, but pharmacies just started handing them to everybody, you know, because it covers them legally. And it's required to be dispensed with certain medications. Okay, so the high-risk drugs that require a boxed warning. Now this says table 6.4, but this is also on page 45 at the bottom of your book. It's called box 2.8. So some of these drugs like Accutane, we talked about Accutane and the pregnancy defects that it can cause. There's Adderall, there's antidepressants, there's estrogen and progesterone, Concerta, Coumadin, NSAIDs, which are non-steroidal anti-inflammatory drugs, which can cause ulcers. Ritalin, Ceravent, Strattera, and Simlin, which can cause low blood sugar in diabetics. So these are some of the drugs that require the medication guides by the FDA, required by the FDA. Now there used to be only 5 lists of drugs in this listing, and it was very easy to remember, and we would get tested on them in our national exam. Now I would look at this list because I've heard that they are asking about some of these. Okay. Pregnancy categories, the FDA established 5 categories. They're on page 46. Page 46. Yeah, I'm getting tired of this. There we go. You guys get to see me edit here. Category A, controlled studies in women show no risk to the fetus. Category B, animal studies fail to show fetal risk. No controlled human studies were conducted, or animal studies show a fetal risk that is not confirmed in human studies. Category C says that animal studies show fetal risk, no controlled human studies were conducted, or no animal or human studies, but the drugs can be given if the benefits justify the risk. So all drugs have a risk and a benefit. They have a risk of side effects. They have a benefit, which is supposed to be their therapeutic effect, like lowering blood pressure, okay? So you have to weigh the risk versus benefit ratio, okay? And then this is true for all drugs, period. So when they're talking about the risk versus the benefit, so category C and D are the ones that they mostly talk about. Category D shows that controlled human studies show a fetal risk. The benefits may be acceptable despite the risks in life-threatening situations. So something like this might be a drug used to treat breast cancer in pregnant women. Category X says that controlled human studies show a fetal risk outweighs any possible benefit, and these are contraindicated in pregnant or potentially pregnant women. So something like Accutane is a category X drug, because if it's for acne, I'm sorry, but you're going to have to live with acne until you have this baby. Then afterwards, as long as you don't breastfeed, you might possibly be able to take Accutane. So you know, that's what category X means. Okay, so now the FDA and the DEA have no authority to determine who can prescribe drugs. So what do we mean when we say the word prescriber? Prescriber is somebody who is allowed to write prescriptions, basically. So in the US, they have to be licensed by their individual state boards. So the standard practitioners in all 50 states are physicians, surgeons, doctors of osteopathy, which is basically bone diseases, dentists, podiatrists, which are foot doctors, veterinarians, of course, which are animal doctors, and optometrists, which are doctors of optometry. But they should only write prescriptions within their own scope of practice or their specialty. So for instance, if you brought in a prescription from your veterinarian for yourself for a blood pressure medication, no pharmacy that I know of would possibly fill it for you, because you should not be under the care of a veterinarian unless you're an animal, right? Who can receive a prescription? Pharmacy technicians are allowed to take in prescriptions, interpret them, and fill them. Technicians in California, at least, cannot take phone orders. Pharmacists have to give the final check. They take verbal telephone orders, and they transfer prescriptions to other pharmacies and receive them from other pharmacies as well. The prescription label, the information on the label is different from the information that's on the prescription. There have to be two necessary components, the pharmacy information and the patient information. Sometimes they have special labeling because of adverse effects or the possibility of teratogenicity to an unborn fetus. Teratogenicity means that it can cause death or harm to an unborn fetus. The label has to have the name, address, and phone number of the pharmacy, the name of the prescriber, the doctor's name, the date the prescription was filled, the prescription number, and cautions and auxiliary labels. Those are just some things on there. There's actually 11 things in California that must be on a prescription bottle. We have special prescribing programs, like programs for opioid maintenance. One of them is called the methadone maintenance treatment. Methadone, which is a C2, is used for treating patients with opiate addiction. No more than 1 day's supply can be given, and it must be taken at a doctor's office or a drug treatment center. That's if the patient is not an inpatient in a hospital. So if they're in an inpatient in a hospital, then that's okay too. Suboxone and Subutex, these are C3s. They require special consent forms to be completed by the patient. They're used for opioid addiction. The treatment must be supervised in a clinical setting. Prescribers have to meet certain criteria, and if met, the DEA issues a special number with an X to identify as a qualified prescriber. One of the ways that we use to mitigate the problems with prescribing Accutane is the I-Pledge program. The FDA regulates that drug because of those severe birth defects or increased risk of suicidality. It's a box warning. Restricted distribution guidelines must be followed before the patient can receive the medication. They can only get a 1-month supply. There's computer-based risk management program, and it's designed to increase awareness of dangers of isotretinoin in an effort to eliminate fetal exposure. There's something called REMS, R-E-M-S. This is the Approved Risk Evaluation and Mitigation Strategies. This is required by the FDA on a lot of drugs, especially tretinoin. For approval of approved products, when a new safety information arises, the strategy is used to manage the known or potential serious risk associated with the drug. The FDA and the DEA recognize certain things as being a pharmacy site. For instance, a brick and mortar store is called a retail pharmacy. There are also big warehouse buildings that house mail order pharmacies. And most of the time you don't walk into those as a patient, you know, and get prescriptions, you know, sold at a counter there. Then there are also e-pharmacies, the National Association of Boards of Pharmacies, NABP. They verify the sites, but they don't regulate them. They have to be regulated by the FDA and the DEA. Now, some of these e-pharmacies There's a huge potential for illegally ordered drugs, and sometimes patients have received counterfeit drugs from e-pharmacies that are based in other countries. So we have to be very careful. There is VIPPS, which is the Verified Internet Pharmacy Practice Sites. And if they get that voluntary accreditation, then they can display that logo on their website. However, you want to be careful because, you know, if they're a counterfeit pharmacy based in, you know, in another country, then it's very difficult to decide for yourself, is this, you know, a real pharmacy working in an ethical way or not? Okay, we talked about the safety data sheets already. There's something called the Joint Commission. It's actually called the Joint Commission on the Accreditation of Healthcare Organizations. Now they just call it the Joint Commission. It was created in 1951 by the American Medical Association and a few other organizations. Their mission is to improve the safety and quality of healthcare via accrediting the healthcare organization. They survey all aspects of hospital services, including pharmacy services. So concerning pharmacy, some of the things they look at are how look-alike, sound-alike drugs are identified. Are they stored separate from each other? How communication, allergy notification, conflicting prescriptions, verbal orders, and other drugs are handled. Okay, legal standards. State law is going to vary by state. So this textbook and the PowerPoint doesn't talk about state law. However, you always run into this question. If federal law and state law are different, which one do you follow? And the answer is always follow the strictest law. Okay, follow the strictest law, because if you follow the strictest law, then you're also not breaking the less strict law, the more lenient law, right? Okay, so that way you're following both of them. There's two types of liabilities, legal liability. The first one is negligence. That's action taken without forethought, like you just don't care, you know, because, you know, you weren't thinking about it. A tort is an act that causes harm or injury to a person either intentionally or because of negligence. So mistakes can be made for a lot of different reasons. Pharmacy technicians can purchase malpractice insurance, which malpractice insurance just helps pay for the defense and any fines that you might accrue by your act of negligence or because of a tort. So malpractice insurance is something that's becoming more and more popular. It's not terribly expensive, but it is an expense. So you have to think about, you know, what kind of practice do you do, and if you think that's right for you or not, and talk to the people that you work with and see if they have it. Okay, the laws are changing regularly. So for right now, in order to stay nationally certified through PTCB, there's continuing education required, and there's 20 units required in a 2-year period. 1 unit must be in pharmacy law, and 1 unit must be in patient safety. So that has to be done every 2 years to recertify. Okay, the law also talks about ethics and morals. Morals are a person's belief concerning right and wrong. Many times a person's morals are related to their religious beliefs. A lot of times it's not related to religious beliefs, but it's what they believe. Ethics are a little bit different. Some people have described them as morals in the workplace, but basically ethics are a set of values and morals used in a profession, and the people in that profession agree on them. Okay, so it's a work ethics, which is a set of standards that should be followed by anyone working in a field. And this concerns in pharmacy responsibility to the patient. Okay, everything we do needs to be for the good of the patient. So professional ethics are a systemic set of rules or principles governing the right to conduct their practice. Each practitioner has a duty to adhere to the standards of ethical practice and conduct set by that profession. Things like respect, honesty, trustworthiness, being an all-around team player, making informed decisions based on training, okay? So those are professional ethics. Okay, so this is the end of this. And box, it says box 213. Let me see if that's the correct page. Okay, but there is a pharmacy technician code of ethics in your book, and that's a good thing to take a look at. Okay. Okay, so we're going to look at the DEA number for a prescription, and it's in your lab book. And I want you guys to do that part too. Okay, so let me find this real quick here. Okay. So in your lab book, on page 17, we're going to look at DEA numbers. Okay, so basically a DEA number is a number given by the DEA to prescribers, pharmacies, hospitals, and other entities like drug wholesalers and manufacturers by the DEA, which is a branch of the Department of Justice. This allows for tracking the authorized prescribing, preparation, and dispensing of controlled substances. So there's 2 letters and 7 numbers in it. The first letter indicates the level of practice and responsibility. For example, physicians, dentists, podiatrists, veterinarians, pharmacies, and hospitals will all have a DEA number that begins with A, B, or F. Okay. Mid-level practitioners, such as a nurse practitioner, physician assistant, or optometrist, will be assigned a DEA number starting with the letter M. M is for mid-level practitioner. Okay, so in general, an A, B, or F number means a doctor. M is a mid-level practitioner. Okay, a mid-level practitioner, such as a physician's assistant, a nurse, a midwife, a registered nurse practitioner, okay, or an optometrist. So now there's other numbers too. Manufacturers are E, an importer is a J, an exporter is a K, but we're really not going to work with those numbers. We're only looking at A, B, F, or M. So one thing to remember about mid-level practitioners is that they have to work under the authority of a doctor. So if they're, say, a psychologist, okay, they are usually working under the authority of a psychiatrist, because a psychiatrist is a doctor and so they're allowed to write prescriptions. A psychologist could have, you know, a master's degree in psychology, and they deal more with therapy for the patient. So they do a lot of group therapy, they do talk therapy, they do behavior modification therapy. They do all of that kind of thing, and they can be very, very helpful for patients, but they're not a medical doctor like a psychiatrist is. So when they prescribe a medication, it has to be within the scope of their practice. So it has to be for a psychological condition like either depression or obsessive compulsive disorder or something like that. But they also have to have the psychiatrist or the medical doctor's DEA number on there as well. So you have to find out which doctor they're prescribing under, okay? And same thing with nurse practitioners and physician's assistants. So the second letter is one of two things. If it's assigned to a business, then that means the second letter will be the first letter of the name of the business or the company that owns the business. So like a pharmacy. But if it's assigned to a doctor, the second letter will be the first letter of the last name of the doctor. And then the next 6 letters are part of a checksum equation to verify the validity of the DEA number itself. And the 7th number is a verification number for the checksum equation, which is all very confusing. So let's look at a DEA number. So the first one is going to be Lisa Turney. And they have a DEA number of AT6379241. Okay, so we want to know, is this a valid DEA number? Lisa Tierney. Okay, so the first letter is an A. So she is a dentist. She's a DDS, which is Doctor of Dental Surgery or something like that. So the letter A does apply to a dentist, okay? And the second letter, so we know the letter A is okay. The second letter should be the first letter of her last name, Dr. Tierney. Yes, that's correct. So now let's look at these other digits, and what we're gonna do is we're gonna do a little math to figure out if they are valid. So we're gonna look at the first, the third, and the 5th number. Okay, so we're going to look at the 6, the 7, and the 2. So you start with the first one, every other number except the last one. So we're going to add 6 plus 7 plus 2. 6 plus 7 plus 2, 8, 9, and 6 are 15. So that gives us 15. Okay, 6 plus 7 plus 2 is 15. Now we're going to look at every other letter starting, or number starting with the second one. So I have little arrows on those. I'm going to look at the 3, the 9, and the 4. And I'm going to add those together, 3 plus 9 plus 4. Which gives us 16. 3 plus 9 plus 4 is 16. However, now I'm going to multiply this one by 2. 16 times 2, 16 and 16 is 32. Okay. So I've multiplied those by 2 and I've gotten 32. So now I'm going to look at these two things, the 15 and the 32, and I'm going to add them together. 15 plus 32 equals 47. Okay, so I've added the 15 and the 32 and I get 47. So look at this number 7 here. This is your check digit. The last digit needs to match the last digit in the DEA number. Does it match? No, it does not match. So this DEA number is invalid. Okay, so this last digit is called your check digit, and this whole equation is called the checksum. Okay, the checksum. So you have to perform the checksum or this little equation to make sure that the number matches. Okay, so there is another example. This one is Spencer Brown, who's a physician's assistant. And he has a DEA number of MB 1178690. Okay, so Spencer Brown, who is a physician's assistant. First of all, a physician's assistant is a mid-level practitioner, so his DEA number starts with an M, which is correct. The first letter of his last name is Brown, and the second letter of the DEA number is a B, and it matches Brown, so that is correct. So now let's look at the math. It's 1178670, so I'm going to add 1 plus 7 plus 6, and I get 14. Okay, now I'm going to look at the second digit and do every other digit. One plus 8 plus 9, which is 18, times 2 is 36. Okay, so 1 plus 8 plus 9 is 18. 18 times 2 is 36. So now I'm going to add 14 plus 32. Sorry, 14 plus 36. Okay, so 14 plus 36 equals 50, and 50 ends in 0. Is 0 the last digit of the DEA number of this doctor? Yes, 0 is the last digit of the DEA number of this doctor, and the math adds up, so it is verified. Okay, that is a verified correct DEA number. Now, we know about this. Lots and lots of people know about this. So you still want to make sure that Spencer Brown PA actually exists and is writing under the authority of a doctor, because, you know, I can make up DEA numbers and you can verify them all day long because I know the math and I know how to do that. So it doesn't necessarily mean that, yes, this is a doctor you can trust, okay, right? They could still do, you know, things they shouldn't do. So I have a lab I'm going to be posting on DEA numbers for you that I want you guys to do this chapter as well, okay? Something else I wanted to talk about regarding this. We went over pregnancy categories, we went over the classes of recall, and we went over the DEA numbers. We went over the top 20 drug laws. So, and you have a list of those, and I want you to do flashcards for those laws. So chapter two is extremely important for pharmacy because it's law, you know, and we have to obey those laws. If we don't obey those laws, we can not only be stripped of our license, we can end up having a fine and going to jail. So, you know, we want to make sure that we know the most important laws and we don't break them, okay? So you're going to be doing the questions at in your lab book, and the same thing I had you do before pretty much, but I want you to actually do a couple of different things in here because there's a lot of interesting things in here. And I'm going to post this lab for you guys, which is not in your book, but it's a good one. So I'll have you guys do that as well. Okay? All right. Thank you so much for listening to my recorded lecture, and I'll talk to you later.